So let's get back, as I said before, we'll get into the law. I'm not going to spend too much time looking at the actual slide here, but 174, Part 4.3 or Part 4, Division 3, this is the key section that looks at what our requirements are when it comes to disclosure. So you are required to disclose as soon as practicable after instructions are given. And the section sets out the requirements for the disclosure. Disclosure is usually directed at the prospective client, who is defined to be the person to or for whom the legal services are being provided. So if there's a third-party payer, costs need to be determined with them, but the actual disclosures might be made differently. So what are you required to disclose? Firstly, the anticipated costs. You also need to disclose the right to negotiate a cost agreement, the right to negotiate a billing method, the rights to receive a bill and to request an itemized bill, and the right to seek assistance from a designated local regulatory authority if there is a dispute about the bill. The disclosure needs to be written. It needs to be written in language that the client can understand, and it needs to set out the ways in which the lawyer will charge and what the likely cost exposure will be. Cost disclosure requirements clearly can protect lawyers, particularly when it comes to allegations made by clients who are disappointed with the outcome of litigation and who are, and I'm taking this quote from Justice Tottle in de Mol, who are apt to forget cautionary advice about costs given by word of mouth. You'll find that when you're looking at the cases, and Delpont focuses particularly on the relevant case law here, that in many cases the relationship between the lawyer and the client is completely broken down by the time there is a dispute in relation to costs. And the complaints about costs are often muddled in with complaints about competency and efficacy and efficiency as well. So the whole point of disclosure is to make it very clear what legal advice is required, what the scope of work will be, and what the costs involved in doing that will be. So the disclosure must be given in writing, and the advice is that it should be separate from the retainer itself. In other words, the disclosure is not a condition of the contract. It is a statement that is completely separate to avoid any impression that every aspect of the statement has legal force. So the cost estimates are estimates at the early stage. They're not an agreed price unless they are an agreed price. So disclosure is about scoping out what it is that you need to do and what the likely costs are going to be, and particularly in litigious circumstances, being able to break down what, if this then that, depending on what happens next, which isn't always in control of the lawyer involved. What happens next in the negotiation, what happens next in the proceedings, costs may blow out or suddenly settle. It really, it's very difficult to determine what the costs are going to be. The communication is really, really important. And honestly, if you miss all of the other duties that you have, do not miss the importance of communicating with your client clearly and transparently what the costs are likely to be. There's a real human element here too, particularly when you're dealing with non-commercial clients who are not regularly litigating, not regularly entering into various transactions. They worry about the time that it's going to take, and because of that information asymmetry, they've got no idea whether you're on the right track or not. So clearly your costs, you can't charge costs that are not fair and reasonable. So that's section 172.2. So that means we need to be able to pull out what is fair and what is reasonable. So a common law, an agreement will be unreasonable if its terms or effect are unreasonable to the client, not to the lawyer, right? It might be unreasonable for you to get out of bed for $10,000 or less than $10,000 in the morning, or for you to write a contract for less than 10 grand, but it's not necessarily reasonable to the client. When you look at the cases, it's often looking at proportionality. So where in an employment matter, for example, the outcome of the client's case was an award of $2,000, but the costs were $8,000, it was held to be an unreasonable cost. So an agreement is unreasonable if its terms or effects are unreasonable to the client. And in determining what is reasonable, we have to look at the time, what would have been reasonable at the time of entering into the agreement on an objective basis and with regard to all the circumstances of the case. Not terribly dissimilar to the tests that you've come across in other circumstances before. The main focus of reasonableness is always going to be on the lawyer's rate of and approach to charging. And the failure to stipulate a rate of charge or an hourly rate or a way of assessing the rate is on its face an unreasonable thing, as the client's unable to assess the reasonableness of the agreement before they get into it. So in most cases, in order to assess whether something's reasonable, they've got to get a sense of how long is it going to take and how much you're going to charge for that time. When thinking about reasonableness of common law, we have the same kind of focus here. So we've got to think about, there's a number of things on the screen here. We look at the level of skill and experience and seniority of the lawyer. We look at the level of complexity, novelty, or difficulty of the issues involved in the matter. How much responsibility is involved? How much time is it going to take? The circumstances of the matter, for example, if it's required to be dealt with really urgently over a public holiday period, the court will consider it much more reasonable to charge a higher fee than if you've got all the time in the world. And of course, the number and importance of the documents involved or the number of witnesses that need to be dealt with, all of these things go into a calculation of what is fair and reasonable. So the uniform law and the common law go beyond those usual grounds available for settling aside contracts when we're talking about commercial contracts when it comes to the legal relationship. Sorry, I feel like I've just stumbled over my words because I'm looking at my notes. This happens from time to time. As a matter of general law, a court will set aside a contract for fraud or unconscionability in fairly limited circumstances. But because of the information asymmetry, because of the ethical position involved, and because of the profession's concern about its standing in the community, a court will go beyond just those requirements of fraud and unconscionability when looking at contracts between lawyers and their clients. And this is because of that special lawyer-client relationship. The fairness aspect is generally seen as relating to the circumstances surrounding the formation of the agreement between the lawyer and the client. Whether the agreement was adequately explained, whether the client appeared to understand it, did the client actually have the ability to exercise any real choice, or whether the solicitor just took advantage of the client in some way. The reasonable aspect, on the other hand, relates to the terms of the agreement itself. On the facts of a particular case where the terms of an agreement and their operation, a court will look at, were they reasonable for this particular client concerned. Have a look at section 207 of the Uniform Law. That provides that a breach of the fair and reasonable requirement in relation to legal costs is capable of being unsatisfactory professional conduct or professional misconduct, either or both. It's going to be really important for you to be on top of the key elements of section 174. And the QR code on that page again goes to a page on the Legal Practice and Board and Commissioners website on the cost rules. It's got some really useful links there, and that's really useful for your exam prep in particular, I suspect. So under section 174(1) of the Uniform Law, law practices are required to provide their clients with an estimate of the total legal costs. So in prior iterations, and quite probably in the states that haven't adopted the uniform law yet, there was provision that allowed for a range of estimates. So the consensus view is that it is no longer possible to specify a range, that best practice requires specifying an estimate of what those costs will be. Often this is done in a staged disclosure way. So the law practice will disclose what the expected steps in a transaction or a piece of litigation will be, and at each step in the transaction or each stage of the transaction, what the costs are likely to evolve. It's also really important to remember that cost disclosure must be in writing, and that the law practice needs to take all reasonable steps to satisfy itself that the client has understood and consented to the proposed course of action, as well as the costs. So this is all bundled in with making sure that our clients understand the advice that we are giving them. There's no requirement to disclose where costs are not likely to exceed $750. In fact, that's pre-GST, so that'd be $825 including GST. So you don't have to spend time disclosing if your fees are going to be $750 or less. And you can have a short form or standard form of disclosure if your fees are going to be $3,000 before GST or less. But over $3,000, excluding GST, full disclosure under section 174 will be required. And again, have a look at section 174(4) for those thresholds. 170 is also important to have a look at, because you don't need to disclose to clients who are commercial or government clients, or to third-party payers. So a commercial or a government client is essentially, it's a very broad definition, but they're essentially sophisticated clients. So another law practice. So technically, barristers do not need to provide this level of disclosure to the law practices that engage them. A public company, a subsidiary of a public company, a liquidator or administrator, and partnerships who have 20 or more persons, so large-ish partnerships, and if there's a tender process for the work, or part of a government authority. Third-party payers, I've mentioned these a couple of times. A third-party payer could be a litigation funder, for example. They're often also public companies or insurance companies, or financial services providers who might be caught out by the commercial government client definition anyway. Third-party payers essentially agree to fund the costs of litigation, or litigation third-party payers anyway, in return for a share of the award or the settlement in the hope of making a profit. So in other words, they hope that they're going to recover more than the costs that they fund. If the obligation to pay costs on the part of the third-party payer is owed to a law practice, whether or not it's also owed to the client or to somebody else entirely, that person is referred to as an associated third-party payer for the purposes of the law. So if the exemption doesn't apply, section 176(1), not on the screen here, but just remember it, 176(1), says that a practice must also make disclosure to the extent that the details are relevant and relate to costs payable. So what about this situation where a law firm retains another law practice? So I mentioned barristers before. The second law practice is not obliged to make its cost disclosure to the client, but it must make it to the first law practice so that the first law practice may in turn disclose those costs to the client. So that's section 175. So barristers provide cost disclosures to solicitors to enable them to be compliant. But if the law practice is engaging the barrister directly, then it doesn't need to provide that same level. 177 sets out some of the other disclosure obligations. Again, these are specific to litigious matters, and you need to really be clear on them. Similarly, you need to be clear on the requirements of section 178, which set out the consequences of failing to fulfill the disclosure requirements. Now, I'm not going to go through the section word by word on the slide again, but let's highlight the too long didn't read requirements. Ultimately, if there is a breach of the disclosure requirements, the uniform law essentially renders any cost agreement void, and the law practice will be prevented from commencing or maintaining any proceedings to recover costs until they've been assessed or determined, or the dispute itself has been determined. So that's 178, subparagraph 1A and C. This conduct is also capable of constituting unsatisfactory professional conduct or even worse, professional misconduct. Then one last point. Unlike the disclosure requirements in the non-participating jurisdictions, so the I was about to say countries, the states that haven't signed up yet, to the uniform law, there's no specific initial requirement for the disclosure or for an estimate of any cost that the client might be required to pay another party if they are unsuccessful. Nor are we required to disclose any contribution that is likely to be received from another party towards those costs if they are successful. And it's kind of incongruent, and we'll talk about that a little bit more when we talk about the kinds of costs that can be recovered in the event that litigation is successful, or paid if it's unsuccessful. And I think really the difficulty in explaining and predicting those goes a long way to the reasoning behind them not being required under the uniform law. And again, always make sure that you remember a uniform law. It's pretty uniform, and it does codify the common law to a large degree, but the specific circumstances in each state may well be different. And that's worth watching out for. So in the next video, we will talk about the costs agreement itself. Yay!